We're going to continue exploring Chapter 6, which is titled Privacy in the Government. And we're going to, in particular, for this lecture, we're going to cover Section 6.4, Section 6.5, and Section 6.6. So Section 6.4 is about covert government surveillance. And we're going to turn to discussing the ways in which the U.S. government has collected information in order to detect and apprehend suspected criminals or to improve national security. So because the individuals being observed are suspected of wrongdoing, they are not alerted or asked for permission before the surveillance begins. So the question is, does covert surveillance violate any of the rights of a citizen? And the most relevant statement in the U.S. Constitution on answering this question is the Fourth Amendment. So the Fourth Amendment says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. All right, well, what's the history behind this amendment? Well, before the American Revolution, English agents in pursuit of smugglers made use of writs of assistance, which gave them authority to enter any house or building and seize any prohibited goods they could find. So this activity drew the ire of the colonists, so it's not surprising then that a prohibition against unreasonable searches and seizures appears in the Bill of Rights. The position of the U.S. Supreme Court with respect to covert electronic surveillance has changed over time. So let's see how the Supreme Court's position has evolved. Wiretapping refers to the interception of a telephone conversation. The term is somewhat anachronistic because many telephone conversations are no longer transmitted over actual wires, but wiretapping has been taking place ever since the 1890s, when telephones became commonly used. And wiretapping was a popular tool for catching bootleggers during Prohibition from 1919 to 1933. And the most famous case involved Roy Olmsted, who ran a $2 million a year bootlegging business in Seattle, Washington, which that's an astounding cash figure for the time. Without a warrant, federal agents tapped Olmsted's phone and collected enough evidence to convict him. And although wiretapping was illegal under Washington law, the state court allowed evidence obtained through the wiretapping to be admitted. Olmsted appealed all the way to the U.S. Supreme Court. His lawyer argued that the police had violated Olmsted's right to privacy by listening in on his telephone conversations. Olmsted's lawyer also argued that the evidence should be thrown out because it was obtained without a search warrant. The public and the press were critical of the Supreme Court decision. Since the court had ruled that wiretapping was constitutional, those interested in prohibiting wiretapping focused their efforts on the legislative branch. So in 1934, the U.S. Congress passed the Federal Communications Act, which, among other things, made it illegal to intercept and reveal wire communications. 3 years later, the Supreme Court used the Federal Communications Act to reverse its position on warrantless wiretaps. So in the Nardone versus United States, the court ruled that evidence obtained by federal agents from warrantless wiretaps was inadmissible in court. In another decision, the Weiss versus United States, it ruled that the prohibition on wiretapping applied to intrastate as well as interstate telephone calls. So subsequently, the Attorney General announced that the FBI would cease wiretapping. But after World War II broke out in Europe, the FBI Director J. Edgar Hoover pressed to have the ban on wiretapping withdrawn. The position of the Department of Justice was that the Federal Communications Act simply prohibited intercepting and revealing telephone conversations. So, in the Justice Department's view, it was permissible to intercept conversations as long as they were not revealed to an agency outside the federal government. President Roosevelt agreed to let the FBI resume wiretapping in cases involving national security, though he asked that the wiretaps be kept to a minimum and limited as much as possible to aliens. Because it knew evidence obtained through wiretapping was inadmissible in court, the FBI began maintaining two sets of files: the official files that contained legally obtained evidence, and confidential files containing evidence obtained from wiretaps and other confidential sources. In case of a trial, only the official file would be released to the court. So the FBI was supposed to get permission from the Department of Justice before installing a wiretap, but in practice it did not always work that way. So during his 48-year reign as director of the FBI, J. Edgar Hoover routinely engaged in political surveillance, tapping the telephones of senators, congressional representatives, and Supreme Court justices. The information the FBI collected on these figures had great political value, even if the recordings revealed no criminal activity. And there is evidence Hoover used information gathered during this surveillance to discredit members of Congress who were trying to limit the power of the FBI. A bug is a hidden microphone used for surveillance, and in a series of decisions, the U.S. Supreme Court gradually came to an understanding that citizens should also be protected from all electronic surveillance conducted without warrants, including bugs. And the key decision was rendered in 1967. Charles Katz used a public telephone to place bets. The FBI placed a bug on the outside of the telephone booth to record Katz's telephone conversations. With this evidence, Katz was convicted of illegal gambling, and the Justice Department argued that since it placed the microphone on the outside of the telephone booth, it did not intrude into the space occupied by Katz. So in Charles Katz versus the United States, the Supreme Court ruled in favor of Katz. Justice Potter Stewart wrote that the Fourth Amendment protects people, not places. And so because Katz, in the reasoning of the Supreme Court, entered the phone booth with the reasonable expectation that his conversation would not be heard, and what a person seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. So during World War II, the U.S. government censored all messages entering and leaving the country, meaning U.S. intelligence agencies had access to all telegram traffic. At the end of the war, the censorship bureaucracy was shut down, and the Signal Security Agency, which was the predecessor to the National Security Agency, wanted to find a new way to get access to telegram traffic. So it contacted Western Union Telegraph Company, ITT Communications, and RCA Communications, and asked them to allow it to make photographic copies of all foreign government telegram traffic that entered, left, or transited the United States. So in other words, the Signal Security Agency asked these companies to break federal law in the interest of national security. All three companies agreed to the request, and the Signal Security Agency gave this intelligence gathering operation the name Shamrock. When the National Security Agency, or the NSA, was formed in 1952, it inherited Operation Shamrock. The sophistication of the surveillance operation took a giant leap forward in the 1960s when the telegram companies converted to computers. Now the contents of telegrams could be transmitted electronically to the NSA, and the NSA could use computers to search for keywords and phrases. In 1961, Robert Kennedy became the new Attorney General of the United States, and he immediately focused his attention on organized crime. He discovered that information about mobsters was scattered piecemeal among the FBI, IRS, Securities and Exchange Commission, and other agencies. So he convened a meeting in which investigators from all of these agencies could exchange information. The Justice Department gave the names of hundreds of alleged crime figures to the NSA, asking that these figures be put on its watch list. And intelligence gathered by the NSA contributed to several prosecutions. So also during the Kennedy administration, the FBI asked the NSA to put on its watch list the names of U.S. citizens and companies doing business with Cuba. So the NSA sent information gathered from intercepted telegrams and international telephone calls back to the FBI. During the Vietnam War, the Johnson and Nixon administrations hypothesized that foreign governments were controlling or influencing the activities of American groups opposed to the war. They asked the NSA to put the names of war protesters on its watch list. Some of the people placed on the watch list included the Reverend Dr. Martin Luther King Jr., the Reverend Ralph Abernathy, Black Panther leader Eldridge Cleaver, pediatrician Dr. Benjamin Spock, folk singer Joan Baez, and actress Jane Fonda. In 1969, President Nixon established the White House Task Force on Heroin Suppression, and the NSA soon became an active participant in the war on drugs, monitoring the phone calls of people put on its drug watch list. Intelligence gathered by the NSA led to convictions for drug-related crimes. Facing hostile congressional and press scrutiny, the NSA called an end to the Operation Shamrock in May of 1975. The FBI developed the Carnivore system in the late 1990s to monitor internet traffic, including email messages. The system itself consisted of a Windows PC and packet sniffing software capable of identifying and recording packets originating from or directed to a particular IP address. Armed with a search warrant, the FBI would set up its Carnivore system at the suspect's internet service provider. In 2000, the Justice Department demanded that Earthlink, an internet service provider, allow the FBI to use Carnivore without a warrant. Earthlink filed a legal challenge questioning the FBI's authority to do this under the Electronic Communications Privacy Act, but a U.S. District Court ruled against Earthlink. Between 1998 and 2000, the FBI used the Carnivore system about 25 times. In late 2001, the FBI stopped using Carnivore, replacing it with commercial software capable of performing the same function. The September 11, 2001 attacks on the World Trade Center and the Pentagon spawned new secret intelligence gathering operations within the United States, and the same question emerged after each activity became public knowledge. Is it constitutional? So early in 2002, the Central Intelligence Agency captured several top al-Qaeda members along with their personal computers and cell phones. The CIA recovered telephone numbers from these devices and provided them to the NSA. The NSA was eager to eavesdrop on these telephone numbers, hoping to gather information that could be used to disrupt future terrorist attacks. President Bush signed a presidential order allowing the NSA to eavesdrop on international telephone calls and international emails initiated by people living inside the United States without first obtaining a search warrant. The list of persons being monitored gradually expanded as the NSA followed connections from the original list of telephone numbers. At any one time, the NSA eavesdropped on up to 500 people inside the United States, including American citizens, permanent residents, and foreigners. The NSA also monitored another 5,000 to 7,000 people living outside the United States at any one time. Sources told the New York Times that the surveillance program had foiled at at least two al-Qaeda plots. An Ohio truck driver, Lyman Ferris's plan to bring down the Brooklyn Bridge with blowtorches, and another scheme to bomb British pubs and train stations. Civil libertarians and some members of Congress objected to the program, arguing that warrantless wiretapping of American citizens violated the Fourth Amendment to the U.S. Constitution. The U.S. Department of Defense created the Threat and Local Observation Notices, or TALON, database in 2003. And the purpose of the database was to collect reports of suspicious activities or terrorist threats near military bases. These reports were submitted by military personnel or civilians and then assessed by Department of Defense experts as either credible or not credible. In December of 2005, NBC News reported that the database contained reports on anti-war protests occurring far from military bases. In July of 2006, the Service Members Legal Defense Network reported that the Talon database contained emails from students at Southern Connecticut State University, the State University of New York at Albany, the University of California, Berkeley, and William Patterson University of New Jersey, who were planning protests against on-campus military recruiting. And the Department of Defense removed many of these reports from Talon after conducting an in-house review that concluded the database should only contain information related to terrorist activity. The American Civil Liberties Union asked Congress to take steps to ensure that Americans may once again exercise their First Amendment rights without fear that they will be tracked in a government database of suspicious activities. In April 2007, the new Undersecretary of Defense for Intelligence recommended that the Talon program be terminated, and the Talon database was shut down on September 17, 2007. All right, Section 6.5 is titled U.S. Legislation Authorizing Wiretapping. So as we've seen, the Federal Communications Act of 1934 made wiretapping illegal. And by 1967, the U.S. Supreme Court had closed the door to wiretapping and bugging performed without a warrant or a court order. But after the Katz decision, police were left without any electronic surveillance tools in their fight against crime. Meanwhile, the United States was in the middle of the Vietnam War. In 1968, the country was rocked by violent anti-war demonstrations and the assassinations of Martin Luther King Jr. and Robert F. Kennedy. Law enforcement agencies pressured Congress to allow wiretapping under some circumstances. Congress responded by passing Title III of the Omnibus Crime Control and Safe Streets Act of 1968. Title III allows a police agency that has obtained a court order to tap a phone for up to 30 days. The government continued to argue that in cases of national security, agencies should be able to tap phones without a warrant. In 1972, the Supreme Court rejected this argument when it ruled that the Fourth Amendment forbids warrantless wiretapping even in cases of national security. The Foreign Intelligence Surveillance Act of 1978, or FISA, provides for judicial and congressional oversight of the government's covert surveillance of foreign governments and their agents. The law allows the president to authorize electronic surveillance of foreign nationals for up to 1 year without a court order, as long as there is little chance that the surveillance will reveal the contents of communications with any U.S. citizens. If communications with U.S. citizens are to be monitored, the government must get a court order from the FISA court. FISA was amended by the Protect America Act of 2007. This act allows the U.S. government to wiretap communications beginning or ending in a foreign country without oversight by the FISA court. In June 2013, the British newspaper The Guardian disclosed that it had received a top secret document outlining how the National Security Agency had obtained direct access to the servers at Google, Facebook, Yahoo, and other internet giants. The document was provided by Edward Snowden, a former employee of NSA contractor Booz Allen Hamilton. The secret program, called PRISM, enables the NSA to access stored information such as email messages and monitor live communications such as Skype and Paltalk conversations without first obtaining search warrants, when the NSA had a reasonable suspicion that the person being investigated is a foreigner outside the United States. According to the secret document, the NSA gained access to the servers of Microsoft in 2007, Yahoo in 2008, Google and Facebook in 2009, YouTube in 2010, Skype and AOL in 2011, and Apple in 2012. All the companies that responded to a request for information by The Guardian denied any knowledge of the PRISM program. The Obama administration provided the following statement: The Guardian and Washington Post articles refer to collection of communications pursuant to Section 702 of the Foreign Intelligence Surveillance Act. This law does not allow the targeting of any U.S. citizen or of any person located within the United States. Congress updated the wiretapping law in 1986 with the passage of the Electronic Communications Privacy Act, or the ECPA. The ECPA allows police to attach two kinds of surveillance devices to a suspect's phone line. If the suspect makes a phone call, a pen register displays the number being dialed. If the suspect gets a phone call, a trap and trace device displays the caller's phone number. While a court order is needed to approve the installation of pen registers and trap and trace devices, prosecutors do not need to demonstrate probable cause, and the approval is virtually automatic. The ECPA also allows police to conduct roving wiretaps, which are wiretaps that move from phone to phone, if they can demonstrate the suspect is attempting to avoid surveillance by using many different phones. The Stored Communications Act, which is part of the Electronic Communications Privacy Act, has significant privacy implications related to the collection of email messages. So under this law, the government does not need a search warrant to obtain from an internet service provider email messages more than 180 days old. In other words, when a computer user allows an internet service provider to store his or her email messages, the user is giving up the expectation of privacy of that information. So in the past, it had been understood that the government needed a court order to gain access to emails under 180 days old. But in 2010, the government asked Yahoo to turn over emails under 180 days old that had already been read by the recipient. Yahoo challenged this request in federal court, supported by Google, the Electronic Frontier Foundation, and the Center for Democracy and Technology, and the government withdrew its demand for the emails. Nearly 50 companies and privacy rights organizations, including AOL, the American Civil Liberties Union, the American Library Association, AT&T, IBM, Intel, Microsoft, and some others, have joined forces to form an organization called Digital Due Process, which is lobbying Congress to update the Electronic Communications Privacy Act. In the past, internet service providers simply transmitted email messages from senders to recipients. But today, most internet service providers supply convenient long-term storage of their customers' emails, and millions of customers take advantage of this service to hold their messages indefinitely. So with the advent of cloud computing, companies such as Amazon, Google, and Microsoft are storing sensitive documents and other materials that in the past would have been held on personal computers. The view of the Digital Due Process Coalition is that the government should not be able to obtain an email message, document, or photo from an internet or cloud service provider without a proper search warrant. So the implementation of digital phone networks interfered with the wiretapping ability of the FBI and other organizations. So in response to these technological changes, Congress passed the Communications Assistance for Law Enforcement Act of 1994, or CALEA, also known as the Digital Telephony Act. This law required that networking equipment used by phone companies be designed or modified so that law enforcement agencies can trace calls, listen in on telephone calls, and intercept email messages. CALEA thereby ensured that court-ordered wiretapping would still be possible even as new digital technologies were being introduced. But CALEA left unanswered many important details about the kind of information the FBI would be able to extract from digital phone calls. The precise requirements were to be worked out between the FBI and industry representatives. The FBI asked for many capabilities, including the ability to intercept digits typed by the caller after the phone call was placed. This feature would let it catch credit card numbers and bank account numbers, for example. In 1999, the FCC issued the guidelines, which included this capability and 5 more requested by the FBI. Privacy rights organizations argued that these capabilities went beyond the authorization of CALEA. And telecommunications companies claimed that implementing these capabilities would cost them billions of dollars. Nevertheless, in August of 2005, the FCC determined that Voice over Internet Protocol, or VoIP, and certain other broadband providers would need to modify their systems as necessary so that law enforcement agencies could wiretap calls made using their services. All right, Section 6.6 is all about the U.S. Patriot Acts, and as you may or may not know, this is related to the morning of September 11th, 2001, when terrorists hijacked 4 passenger airliners in the United States and turned them into basically flying bombs. 2 of the planes flew into New York's World Trade Center, a 3rd plane hit the Pentagon, and the 4th plane crashed in a field in Pennsylvania. Soon after these attacks, which resulted in about 3,000 deaths and the destruction of the Twin Towers of the World Trade Center, the U.S. Congress passed the Uniting and Strengthening America by providing appropriate tools required to intercept and obstruct Terrorism Act, or the USA Patriot Act of 2001, henceforth referred to as the Patriot Act. The Patriot Act has raised many questions about the extent to which government agencies should be able to collect information about individuals in the United States without first obtaining a search warrant. The Patriot Act amended many existing laws. Its provisions fall into 4 principal categories. Number 1, providing federal law enforcement and intelligence officials with greater authority to monitor communications. Number 2, giving the Secretary of the Treasury greater powers to regulate banks, preventing them from being used to launder foreign money. Number 3, making it more difficult for terrorists to enter the United States. And number 4, defining new crimes and penalties for terrorist activity. So we're going to focus on those provisions of the Patriot Act that most directly affect the privacy of persons living inside the United States. So critics say the Patriot Act undermines the 4th Amendment rights because the Patriot Act expands the kinds of information that law enforcement officials can gather with pen registers and trap and trace devices. For example, it allows police to use pen registers on the internet to track email addresses and URLs. The law does not require that they demonstrate probable cause. So to obtain a warrant, police simply certify that the information to be gained is relevant to an ongoing criminal investigation. Secondly, the Patriot Act broadened the number of circumstances under which roving surveillance can take place. Um, the Patriot Act allows roving surveillance to be performed for the purpose of intelligence, and the government does not have to prove that the person under investigation actually used the device to be tapped. And then the Patriot Act also allows courts to authorize law enforcement officers to search a person's premises without first serving a search warrant when there is a reasonable cause to believe that providing immediate notification of the execution of the warrant may have an adverse effect. The Patriot Act expanded the use of national security letters, making it easier for the FBI to collect internet, business, medical, educational, library, and church or mosque or synagogue records. So to obtain a search warrant authorizing the collection of records about an individual, the FBI merely needs to issue a national security letter stating that the records are related to an ongoing investigation. The Patriot Act does specifically prohibit the FBI from investigating citizens solely on the basis of activities protected by the First Amendment. A typical national security letter contains a gag order that forbids the letter's recipient from disclosing receipt of the letter. National security letters are controversial because, unlike warrants, they do not require the approval of a judge. That means there is no need for the FBI to show probable cause. And between 2003 and 2006, the FBI issued 192,499 national security letters. According to Tom Ridge, the former Secretary of the Department of Homeland Security, the Patriot Act has helped the government in its fight against terrorism by allowing greater information sharing among law enforcement and intelligence agencies, and by giving law enforcement agencies new tools to investigate, many of which have been used for years to catch mafia dons and drug kingpins. Terrorism investigations have led to charges being brought against 361 individuals in the United States, and of these, 191 have been convicted or pled guilty, including shoe bomber Richard Reed and John Walker Lind, who fought with the Taliban in Afghanistan. More than 500 individuals linked to the September 11th attacks have been removed from the United States. Terrorist cells in Buffalo, Seattle, Tampa, and Portland have been broken up as well. Unfortunately, though, a few innocent bystanders have been affected by the war against terrorism. A notable example is Brandon Mayfield. So during the morning rush hour on March 11th of 2004, 10 bombs exploded on 4 commuter trains in Madrid, Spain, killing 191 people and wounding more than 2,000 others. The Spanish government retrieved a partial fingerprint from a bag of detonators, and the FBI linked the fingerprint to Brandon Mayfield, who was an attorney in Portland, Oregon. Without revealing their search warrant, FBI agents secretly entered Mayfield's home multiple times, making copies of documents and computer hard drives, collecting 10 DNA samples, removing 6 cigarette butts for DNA analysis, and taking 355 digital photographs. The FBI also put Mayfield under electronic surveillance. On May 6 of 2004, the FBI arrested Mayfield as a material witness and detained him for 2 weeks. After the Spanish government announced that it had matched the fingerprints to an Algerian national living in Spain, instead of Mayfield, a judge ordered that Mayfield be released, and the FBI publicly apologized for the fingerprint misidentification. Some civil rights groups suggested that Mayfield was targeted by the FBI because of his religious beliefs. The affidavit that the FBI used to get an arrest warrant pointed out that Mayfield had converted to Islam, is married to an Egyptian-born woman, and had once briefly represented a member of the Portland Seven in a child custody case. Mayfield sued the U.S. government for continuing to investigate him after the Spanish police had eliminated him as a suspect, and in November of 2006, the government issued a formal apology and agreed to pay him $2 million. Beginning in 2011, two members of the Intelligence Committee of the U.S. Senate, Ron Wyden of Oregon and Mark Udall of Arizona, repeatedly spoke out against domestic spying. In May 2011, Senator Wyden said, "I want to deliver a warning this afternoon. When the American people find out how their government has secretly interpreted the Patriot Act, they will be stunned and they will be angry." 2 years later, Americans began to learn what Senator Wyden was talking about. On June 5th of 2013, the British newspaper The Guardian revealed that, based on a request from the FBI, the Foreign Intelligence Surveillance Court had ordered Verizon to provide to the National Security Agency on a daily basis records of all of its customers' calls from April 25th of 2013 to July 19th of 2013. And Edward Snowden was responsible for leaking this information to The Guardian. These call records, which are also called telephony metadata, included the date and time of each telephone call and the location of the phone making the call, the duration of the conversation, and other identifying information. Verizon was not asked to provide the contents of the conversations. The order from the Foreign Intelligence Surveillance Court, or FISC, expressly prohibited Verizon from revealing to the public the FBI's request for this information. The Guardian reported that these recent events reflect how profoundly the NSA's mission has transformed from an agency exclusively devoted to foreign intelligence gathering into one that focuses increasingly on domestic communications. In May of 2015, a federal court in New York ruled that the NSA's program to collect customer telephone call records in bulk was illegal. According to the U.S. Court of Appeals for the Second Circuit, it is unreasonable to interpret Section 215 of the Patriot Act as authorizing the bulk collection of telephone calling records. Section 215 of the Patriot Act expired on June 1st, 2015. Instead of renewing Section 215, Congress passed a reform of Section 215 called the U.S. Freedom Act. The U.S. Freedom Act put new restrictions on the government's surveillance activities. In particular, it shifted the bulk collection of telephone records to the phone companies and required government agencies to obtain a court order before accessing them.